Welcome out to A Case for America. This is your host, Austin Hepworth, here along with Michael Hepworth. And we love talking about America and the things that make America a land of prosperity, a land of freedom, and a place that most people still want to be, even with all that goes on in the world. Today, we are focusing on the Sixth Amendment as we talk about what the Sixth Amendment is. And as a reminder, kind of about the way that we look at things, we feel very strongly that the state of liberty, the state that America has tried to achieve over the years, is a state that's not in anarchy. It pulls us out of anarchy, and laws do that. Laws are necessary to create a state that's not just anarchy where the most powerful wins. But to keep us from tyranny, we have to have morality, and we have to have private solutions and communities and people doing things of their own free will and volition. And so when we talk in A Case for America, we try to focus on both the legal side, the morality side. We don't always know exactly where the balance is ourselves. Sometimes to find the balance, you need people that have a deep understanding of the particular issues and where those may be. But we hope that these podcast series really encourage discussion among people so that we can get closer and closer to where that appropriate balance is in America. We do feel America is off balance currently in a number of places, and that by restoring the balance, America will be more prosperous, more stable. And so that's something that we definitely advocate and push for. But with the Sixth Amendment, when we talk about it, the Sixth Amendment has, depending on how you break things up, 8 or 9 rights in it. It says in all criminal prosecutions. So right now we're talking about the criminal side of things. This means you can go to jail for something. The accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So this is often viewed by many as rights, criminal rights, or rights that are granted to those that have done bad things. And it certainly shakes out that way. We see it often in play that way. But I think the piece to remember, the bigger picture here, is when the founders had lived under a system where the king could make anything or anyone illegal or a criminal and throw people in jail, it's a system where there wasn't much liberty. It's just a state of, well, king said you're a criminal today, he doesn't like you, so you go to jail. And one of the things the founders really wanted to do was to make America a land ruled by law and not by a particular person. So they set up checks and balances. And the Sixth Amendment was a very significant step forward in creating checks and balances on the government's power to imprison people. And so one reason why we see this only apply to a criminal generally and those that have done bad things, at least that's how we often interpret it, is that this check and balance actually works really well. America does have some innocent people imprisoned at times, but for the most part, the system works very well to guard against too many situations of large amounts of innocent people being accused of things, being dragged through trials, being sent to jail. And again, there are situations. The Innocence Project is one that can point to times when innocent people have been convicted, and it's not to say it never happens. But sheer number-wise, percent-wise, it's pretty amazing how good the system is generally at focusing on those that have done something wrong. And even within that, there's definitely grounds to argue that not all laws that criminalize things should be criminal. And that's a whole nother topic for another day. But in general, if you think about murder, think about rape, you think about burglary, theft, some of the more serious crimes, for the most part, we are bringing people to justice that were actually involved with those things. And so I view the Sixth Amendment and the system set up by the founders as being um, pretty good and pretty remarkable in trying to help America have a balance where guilty can be prosecuted. There is a way to do that, and the innocent can be protected from governmental overreach. And so just keep that in mind as we talk about some of these, because sometimes we think, why does someone that's actually guilty need it? And to be honest, someone that's actually guilty probably doesn't need all these rights. But again, this is more of a check on the government to stop it from coming after people that aren't actually guilty. And so by putting these blocks in place or these requirements in place, then the system creates checks and balances to help people be a little more free. So first, in looking at the accused enjoying the right to a speedy and public trial, there's two aspects here. One is speedy and one is public. And you can ask yourself, well, what does speedy mean? Michael, you have any idea how long a trial takes?
Quite a while. I was trying to find this answer, and I got a lot of information because the answer is kind of complicated. But if you just talk about a trial and you define it as just like time spent in court, it may not actually be that long. You could spend, maybe on average, you hear about some trials lasting a week or 2 weeks or something, but on average, a trial lasts a few hours to a day as far as hours spent in court. But it's the time leading up to that and getting the trial date set and all that. It's usually what takes the most time. And it depends on the court. It depends on the state. It depends on the county. If it's a federal, if it's not federal, if it's a misdemeanor charge, or if it's a felony charge. All these things kind of play into how long it takes. And it's a really complicated answer. But there's a group that kind of tried to find out on average how long were felony cases resolved, how long were misdemeanor cases resolved. They're looking at states. They've found that they kind of grouped courts into timely courts, mid-range courts, and less timely courts. Timely courts were getting 90% of their felony cases resolved within a year, which is a very long time. So the timely court was doing 90% in about a year. The less timely courts were only managing about 75% in a year. So that's 25% of the cases taking up to 2 years many times. And this is for resolution. So again, it's not actually time just spent in the court. There's a lot that goes into a trial, as in preparation by lawyers and picking out juries and all kinds of things go into it. But it's a really complicated process. And so as I was trying to find the answer to this, one of the things that struck me was just how complicated it was and how different it is depending on the state, depending on the county, depending on what the charge is. This group I'm looking at kind of went through and defined what they term to be higher and lower courts, which is kind of two court systems set up in most states where many times misdemeanors will go to one, felonies will go to another. Many states kind of mix that up. They put misdemeanors into one, then into the other. Sometimes they put felonies through both, and it differs by state. So an example they give, they had about 4 different groupings over the states they looked at for different methods that cases could take as they move through these different court systems. And it just struck me how complicated it was. Nobody can look at this and say this is how long a trial takes, because each trial kind of has its own process depending on what the charge is. And I just thought about that in connection to the Sixth Amendment, talking about a speedy trial. talking about the impartial jury, and I thought, how can you be speedy and impartial and fair when it's that complicated? Because an individual who's charged has no idea what they're getting into. Let's say they're charged with some sort of misdemeanor. There's so many different times they have to show up and nothing happens. There's all these conversations they have with lawyers as they're prepping, and maybe you'll get to trial, maybe you won't, depending on settlements. And it's just so complicated. I don't know how an individual can understand the process across the board. And so it's complicated. It takes a long time. If you really wanted to dig into how long does a trial take, you're going to get a different answer depending on the number of variables that you put in.
Yeah. And it is pretty wild because it's something clients will ask me. I don't do criminal law, but whenever someone does get sued or there's a court case, they always say, how long will this take? And it's 1 to 3 years, somewhere in there, depending on everything that happens in the middle of it all. And so courts, when they look at least whether you've had a speedy trial in the criminal context, they'll look generally to 4 factors. They'll look at the length of delay to see if they've waited too long. There's not a hard and fast rule that judges have made for how long that is, because they'll also look at the reasons for the delay, and they'll look at the time and manner in which the defendant asserted their rights to a speedy trial, or if they waived their rights to a speedy trial. And then the degree to which the defendant's been prejudiced. You know, if there's witnesses that have died, or if there's evidence that no longer exists, or memories that have faded. Those are some of the things they'll look at. But it is a little bit interesting with the speedy trial, because if you look at a case, there's the Lori Daybell case that had a lot of national attention. She was accused of helping to kill her 2 children. She married this doomsday type prophet guy that would, prophesy about different things. And their kids were found dead and buried in the yard. She's from Idaho, and she's trying to get her charges dismissed on the fact that her right to a speedy trial was violated. She was found guilty on all counts, and so she's filed a motion. She did file a motion on that. It was denied by the judge. But one of the things that happened in hers is that she had to have a number of hearings to determine if she was competent or not to even stand trial. And so Idaho does have, by statute, a very specific time requirement. It says that if a defendant does not waive the right to a speedy trial, they have to have the trial within 6 months of being, they call it, of being arraigned, when you get taken into court and the charges read against you. And so she didn't get her trial within 6 months, moves to dismiss. Now, the courts so far have determined that if your right to a speedy trial is violated, they are going to dismiss all charges and release you from jail if that happened. So it's a way that she's trying to get out. And one of the questions to ask is, well, why do we need a right to a speedy trial? What purpose does it serve? And this is where you go back to something like, if you look at Guantanamo Bay, and this is still going on, it's outrageous to me and pretty crazy to me. But this is one of the abuses the founders were guarding against. And we have people, alleged terrorists, held at Guantanamo Bay. They're not on American soil. That were picked up by the CIA, put in jail. And they've been there over 20 years for the attacks on New York with 9/11. And they've never been tried yet. And to me, that's so wrong that we just pick people up, put them in jail, allege they're a terrorist. Obviously, these weren't the ones that actually carried out the attacks. Those ones are dead. They were killed in the plane crashes, but they're ones that are alleged to have assisted or helped plan, but no trial. And over 20 years, sitting in these American jails that aren't on American soil. And the CIA circumvents the right to a speedy trial by putting people in jail that are not American citizens on in prisons off of American soil. And the courts have allowed them to do that. And so to me, that's one pretty egregious violation. We need to be trying people, but it's something that could happen here if we didn't have the right to the speedy trial, that you could be just thrown in jail and stuck there while someone gets around to it. And if they don't have a lot of evidence against you, they would have no motivation to really push that forward and let you get out of jail.
I think that's a great point we take further, because many people might consider some of the people detained at Guantanamo Bay to be terrorists, and maybe they haven't considered their rights. Maybe they're like, well, they're not American citizens. But if we think about just you, if you were ever accused of something, would you want the right to a speedy trial, or would you want, just because there's an accusation against you, the government to have the right to just hold on to you in prison as long as they want? Maybe they know that they have nothing on you and they just need you out of the way. And so they say, all right, we'll just put you in prison and we'll just hang on to you with an accusation. And then I think you can kind of see the importance of the speedy trial. It puts the burden on the government, on the accuser, to say, there's a reason for this. I can't just get you out of the way via an accusation and then spirit you off to jail and hold you there. The right to the speedy trial provides that impetus to say there's a reason, and we're going to show via proof that there's a reason that we've accused somebody of something. Otherwise, yeah, they could just put you in jail and let you sit there and say, well, they're a bad person, and so we need to get them out of the way. And we'll have a trial at some later date.
Yeah, and again, it's the fact that we don't see it and we go, well, that's crazy in some ways. Who would do that? Means that the system's working really well. This is a check and balance that's been a really good thing to have in place, because we don't see people just rotting in jail, just someone disappearing and then going, oh, they haven't had their trial yet. It's been 10 years. But that did happen, and it still happens when the government has power to let it happen. And so to me, it's an important thing to note that the founders were very wise with that one, and we should, I believe, really work to uphold it. One of the places where I have extreme concern with one of the ways we're circumventing the right to a speedy trial is that there are cases where the government investigates and they even know who they're investigating. And so just to highlight a very public example of this, Danny Masterson, he's from that 70s show. I think he was the actor in that. He was recently put in jail for rape on rape allegations that surfaced. He supposedly raped some people 20 years ago. And at the time, the police investigated and determined there wasn't anything. And it went on, and no charges brought, nothing. And then later, 20 years after the fact, he's tried and put in jail for the rapes. Now, I'm not here taking his side saying whether he did or didn't do something. I have no idea. But looking at it and reading through it, it wasn't that, they needed more evidence. They didn't really have any more evidence to put in. So much of what could have been argued or defended at the time was lost. Memories changed significantly. Even when there were 3 women that accused him of rape, all of them had significant changes in their stories over the years because they had told their stories multiple times. One of them even stated openly that the relationship was consensual, and she changed that version of things 10 or 12 years after the fact to be non-consensual. And part of that was she alleges she left her religion and she had been brainwashed in her religion. It's kind of her claim. But there were a lot of concerning things in that, and I look at that and go, Yeah, there weren't charges filed against him, so it didn't formally kick in the right to a speedy trial with the way the courts have interpreted it. But to me, I kind of view it as, if you're going to be accused of something, you need the ability to have it tried on the facts and circumstances that are fairly fresh, not 20 years after the fact. That's one of the reasons to have the right to a speedy trial too, is that memories fade, stories change, all these things happen. And so part of it is, hey, if I did something and you're accusing me of doing something, put me on trial right away. And so I do think that one place we may still be off balance is in the ability to bring criminal charges long after the fact when the person was known. The investigation was there. There's no new evidence that surfaced, nothing new that came up. It's one thing if you're searching for a killer for 20 years and you can't find them and you finally find them. That to me is a little bit different than knowing, investigating, deciding not to do anything and just sitting on it for 15, 20 years. So one thing to be aware of is that, again, I think the right to a speedy trial is generally enforced, but we did talk a little bit in another episode about this. The accused is considered to have the right constitutionally to waive the right to a speedy trial. So we've talked some about, can you waive constitutional rights? Can you not? This is one that you are determined to be able to waive. But what happens is that a murder suspect, for example, can waive the right to a speedy trial. They can await trial. Maybe they're in jail, maybe they're out on bail for 3-4 years because it's a murder case, it's higher stakes. And the family of the victim, or even if it was an attempted murder, that person is sitting there living in fear still that person comes back around, or a rape scenario or something like that. And one of the things I feel that we should potentially consider is saying to waive a right to a speedy trial requires both the accused and the victim that agree to that, because trials are important closure for victims. And if there is charges filed, I don't believe that the defendant should have the sole right to drag it out and make it much worse for the victims. The victim should have a right to speedy closure as well. And to me, that's an area that I believe that we could potentially get states and the government on board with to say, to waive right to a speedy trial, a victim has a say in that. So just one thought to think about as we talk about checks and balances and maybe how things are shaken out. Another piece of this is the right to a public trial. The right to the public trial is not absolute. The courts will allow trials to be closed at times if too much publicity will, in their opinion, impede the defendant's ability to get a fair and impartial trial, because the Constitution also requires a fair and impartial trial. And sometimes there's so much news on something that it gets difficult. And just imagine, and I still don't fully know how to deal with this type of scenario, but Trump's on trial for a number of things. And if you are one of the poor jurors in a situation where you feel Trump or others are making threats against you, it makes it difficult to do things and to be part of that. And so the courts have held there are times they can close trials to the public. But in general, the right to a public trial is pretty important, because then everybody can see what happens. And when there's light that shines on it, it helps that, it wasn't just a sham trial. It wasn't just you taken into a court, closed doors, no one knows what happens, and suddenly you're in jail. It forces them to follow the law when it's a public trial. So again, my opinion, typically a good thing. Talking about juries, it's interesting. I don't know how many of you listening have ever been called to jury duty or served on a jury. I personally have been called to jury maybe 3 times and served once. And it was an interesting experience. It was a one-day trial for me, where we were selected and had the trial all on the same day. And it was something, I know the juries get knocked a lot for, I'd say, people tend to disrespect juries quite a bit, saying that they don't know what's going on or they make weird decisions. But I know for the one I served on, people took it very seriously. It was very professionally conducted by everybody there. We fully went through things. We didn't agree at the start. We were split 50-50 basically at the beginning. But by the end, we all agreed unanimously. And it was, to me, very neat to see how well people took that responsibility and how well what I feel the process went. And it was really encouraging to me to go, yeah, I'm sure there's been a situation or two where a jury's off the rocker. But there's situations where judges are off the rocker. And when you get 6 to 12 people in a room, you have a better chance of them taking it seriously than you do with just one judge. I don't know if you saw recently, there's a judge, I think in Oklahoma, that was texting during I want to say a murder trial. And she sent hundreds and hundreds of texts, and she was texting the bailiff and making fun of the person being tried and the attorneys and making offhanded sexual remarks and all kinds of things. Pretty egregious stuff. And so she'll probably be removed from the bench. She's a pretty new judge too, but certainly, again, I'm not saying all judges are bad, but just saying if you have 6 to 12 people sitting on a jury and most haven't been there before, they're going to take it pretty seriously, I think, and try very hard to do a good job with that. But Michael, I don't know if you have any idea how many people in America serve on juries or get called to juries, what we're talking about with that number-wise.
Yeah, the estimates I was able to find were somewhere in the realm of 32 million Americans get summoned each year. About 5% of that actually end up serving on the juries. So in my experience, I've been summoned twice, but never had to go. The summons was, hey, you're going to be jury duty. If we call you, you need to show up on this day. And then I was never called. So that's many people's experience, is they get a summons and then they never actually have to go, or they end up going and then they don't stay for the trial. There's not a lot of people that actually do it as a percentage of total Americans, but it's kind of surprising given the number of trials. But yeah, it's not a whole lot. I think I liked your point about the number of, or getting 6 to 12 jurors in there, even if they don't, as people like to say, know what's going on. I think there's two sides to that. Number one is, why are we making things so complicated that a group of people can't sit down and understand the law? And then number two, as somebody who's accused, I would like to have the accusation looked at by individuals who maybe have a similar life experience to me, not somebody who sees me only through the eyes of the law, as a judge might or a police officer might. Not that is something wrong, but if all day you just see individuals accused of things and you're just looking at how the law applies to them, perhaps your perception of that is different than individuals who are going to work that day, going to school, whatever. They come in and they look at somebody who's been accused. People aren't perfect, and you're not going to find perfect people to be jurors. You're not going to find perfect people to be judges. But I think a really good solution to that is what we have in juries made up of individuals from the community who can come in and kind of listen to what's being, accused.
Yeah, and it certainly, I know the founders felt fairly strongly about juries, at least if you read some of the writings. And it's a real interesting check, like you say, if you're a judge and you see something all the time, you can become a little callous to it and maybe you forget a little bit about reality and just what's taking place, and the juries just serve an important check on that. And the Constitution says it's supposed to be an impartial jury, which means that you have to ask questions of the jurors. You have to see if they're racist, if they're bigoted. You try and go through and weed out people to be able to understand if you're getting a jury that can be fair. You know, one of the questions they often ask in criminal trials is if a policeman testifies, are you going to believe the police more? Or are you going to not believe them because they're a policeman? Or can you just take their testimony at face value and understand that they're human too? And because in most criminal trials, there'll be a police officer testifying to some extent. And it is interesting. You know, there's certainly some people that say, I hate the police. I don't believe anything they say. Others that say, oh, I love the police. I totally believe everything they said, wouldn't even question it. And so there's certainly ways you can lie to get out of jury duty. If you, I mean, I'm not saying those people are lying. Those people may be telling the truth. But if you don't have strong feelings, some people will try and lie to get out of jury duty or get disqualified. But I'd really encourage you, if you get called to jury duty, you know, don't be afraid of it. I mean, I would honestly be afraid of serving on a jury that's trying President Trump or something. But in general, it's a really neat experience. And to be able to be part of the process and see the checks and balances that are set up is a really, really neat thing. And from my understanding, there's currently still a fairly strong view in America that serving on a jury is an important thing to do. That's something that Americans take pretty seriously. And I'm always amazed how little states pay jurors. I don't even think jurors make minimum wage in a lot of states if they're called to jury duty. I'd be a fan of saying at least the state has to pay them whatever the state's made the minimum wage per hour that they have to sit there. And with how little the jurors are used, I don't think it'd be a huge expense. But again, it's something that they haven't focused on extensively. There's not a lot of talk about. And so juror payments tend to stay very low to compensate people for their time. And so maybe we need to start a fair juror pay movement or something. But yeah, that's probably a little less important, but again, still one that I've often wondered why it gets overlooked so readily. And one of the things to know about juries is jurors find facts. They don't determine necessarily what the law is, but they will determine if the facts show that they were guilty or not guilty. And a jury, in conjunction with the double jeopardy clause, once a jury has made a finding of not guilty, that can't be re-examined in court by an appellate court. And so jurors enjoy what they call the power of jury nullification, where they can say, we don't like this law. And if all of them agree that, Joe is out doing his best and this law is just a crazy application outside the realm of what it's supposed to, or it's not just, or it's not fair, they can say not guilty. And government can't do anything about that. So it is pretty fascinating to put this check in the hands of the people. But again, I think it's worked very well. And for all the criticism that comes in about the jury system, I believe it's a very important check and balance. Now, that being said, one of the interesting things to understand about juries and the Sixth Amendment in general is that we say, well, I shouldn't say we, but it's often said, especially by people that are conservative or what they feel are original constitutionalists, they'll say that the Constitution only grants negative rights, meaning it's just guaranteeing you rights that already exist. And they view it as the government should give you rights to the freedom of speech, for example. The government doesn't have to do anything to make that happen. And a lot of people will say that the Constitution doesn't include positive rights. And they will try and say that any type of positive right is bad. So a right to health care, for example, would be considered a positive right because it would require someone else to work to provide that right to you. And it's not just one that can just exist if no one does anything. Your right to healthcare doesn't exist if no one does anything. And so that's one of the ways people try and distinguish what they feel are good rights or bad rights based on whether they're positive or negative rights. But in those discussions, I rarely, if ever, hear anyone mention the fact that the Constitution actually has some very strong positive rights in them. And the Sixth Amendment's one of those examples. The only way you can have a right to a jury trial is to force people to do something. And the only way you can have the right to be defended by legal counsel, which is another one of the rights, is if you force people to do something. It's not, you can't guarantee that kind of right without someone having to act to provide it for you. And so the speedy trial, you know, these are things where judges have to be available, people have to act, the system has to work. And the founders did feel to create a true check and balance, there had to be some positive rights that existed in the Constitution even. And they certainly kept those limited to the criminal realm, but in the area of criminal, trying to have that check and balance on the government's power to put people in jail, the founders did put in some positive rights. And I just always try and talk about, how things are with these, that, yep, some of our basic checks and balances rely on positive rights. And so when we're talking about what rights may or may not be a good idea, I personally believe we need to use some additional principles besides just is it a positive or negative right. I think we need to be able to articulate, go a little bit deeper to say, well, is it putting a check on government? Is there some type of check and balance in place with it? Is there a way to create a system of checks and balances with only negative rights, or do you have to use positive rights to some extent in that? And then to be honest in conversations about other things to say, well, there are some positive rights that in my opinion and the opinion of others would be very difficult to grant or hard to give meaning to, and that could produce, lend towards a state of tyranny, get us closer to that. But again, I don't feel we can dismiss them just because it's a positive right. I think we need to talk about other principles involved with it. So going on with the Sixth Amendment, we have also to be informed of the nature and cause of the accusation. So the government has to tell you which law you broke and why they feel you broke it. And that's part of the filings that take place with these is you get notice. It goes back to due process. And so they're spelling out some elements of due process here to say you need notice of what you've been charged with. Now, this next one, talking about being confronted with witnesses, this gets a little bit difficult in all areas because if you're accused, you have the right to see your witnesses and question them. And in general, I think that's a very necessary thing to be able to know who's accusing you of things and what they're saying and to be able to question them. It certainly produces some difficulty in our time with cases charging people with sexual misconduct. In general, you're going to have, or maybe I shouldn't even say in general, but this is a situation that pops up. There'll be a man, and maybe they're controlling, maybe they're mean, maybe they're threatened, maybe the women have experience with a person. And if he's accused of any type of sexual violence, sexual misconduct against these women, the women have to come in and testify with the man there. And there's certainly women that can do that and have done that. But it is, I think, important to note it's a very difficult task for a lot of women who have truly been assaulted or traumatized to go in and face the person that did that again and to be there in court with them. And it especially gets troublesome and difficult in situations where fathers molest children, because then the father has a right to say, well, put my kid up on the stand and make him testify. And I think that when we look at sexual violence and those types of things, I think it's important to understand, what difficulties come up with requiring that the person be there present. I've often wondered sometimes if it could be where, and again, I haven't fully thought through all these or articulated all of these, so I'd be very interested to know other people's feelings. But even scenarios where maybe the accused is in a different room, maybe they're watching by video feed or something, but they're not in the same room, and their attorneys can still be there. Their attorneys can still represent their interests and question and do things. Um, and to try and make situations where a child testifying against a father, for example, to help those situations be more palatable for the witnesses and potentially make it so that people feel more comfortable telling the truth if they're not in the presence of the person that caused them so much harm. Michael, I don't know if you have any thoughts. I'm just kind of shooting off the cuff with some of those thoughts, but it's been one where I have wondered, because I could see some situations where it'd be very difficult to go in and be a witness against someone for certain types of people.
Yeah, I've had many of the same thoughts. If we can have technology work for us a little bit in this case, that might be beneficial. That isn't to say, I don't want to say, hey, let's just do away with being able to be confronted with the witness. That's kind of risen at an issue that people see with traffic cameras. They don't like to be driving down the road and have a piece of technology take a picture saying you're going too fast, and you're not able to really say who's accusing me, who saw me. It was a computer. Is that, does that really count? And you can see how this might get troublesome if there's an interesting conversation at work that they were discussing what they would be willing to let an AI powered device do in their lives. And it started to get down to law enforcement principles. Would you let an AI powered device enforce certain laws? And interestingly, no one brought up this amendment. No one seemed to really care if they were able to face their accuser. But I think if a machine ever brought an accusation against you, you would be pretty interested to be able to talk to somebody who actually accused you. You can't have a back and forth with a machine, right? I think that's part of what this gets at. And so, to your point, I think it's balancing the two. It's how can we make sure that people are in this process? People are accusing people and people are defending people. But how do we make it so that individuals who really suffered have a way to bring their complaint forth without, you get into certain situations with individuals who've been abused. It's such a mental trauma that to get them in front of the individual, they may not be able to speak. And so how do we allow, in those cases, justice to proceed, I think is a question we really should consider. And to your point, technology might be able to aid us in that regard.
Yeah, and I certainly appreciate you bringing up traffic cameras and AI police, because I've often, I have accounts that track how many people come to my webpage, for example, Google Analytics or whatever it is. And I think almost any business does, or if you're on LinkedIn and it tells you, oh, you had this many page views, or someone, viewed your profile. I often think, how do I know it's even telling me the truth or not the truth? It's kind of like on with Twitter, they were accused of just having a ton of bots that clicked on things. But if they say, for example, oh, your post got 1,000 clicks, well, how do you know? How do you even prove that with technology? If the software is lying to you, how is that proven? If the traffic cameras are just clicking anyone going 45 because for whatever reason they were doing that day, and the speed limit's 45, but they're citing you and saying you're going 55, how do you prove or disprove that? And it does get a lot more difficult when you don't have the human to go against in court. People have kind of joked about it to some extent with, well, if a self-driving car gets in an accident, who's at fault? But it is this interesting note to say, wow, if we just become fully reliant on technology and it's just, oh, the gun said 55, so therefore it's 55, and we just trust it, it could definitely lead to some serious abuses. And I don't think we've even remotely started to produce a good way to have checks and balances on technology or on the results that technology may put out.
And just another note on that, so that maybe some people aren't as uncomfortable. It's not that we're saying technology lies or doesn't lie. I think to lie, you have to be a human. But to say that it's not mistaken or not giving the output that we always desire, this happens all the time. So I work with technology every day, and there are days that we don't know why something happened. And we could research for years and not find it out. It's a consequence of the complexity of the tools we have and of the, for lack of a better term, outsourcing. We use tools from other companies all the time. We use our own tools. There are layers and layers and layers of code involved. Some of it we have access to, some of it we don't. And to actually know what happened is sometimes impossible. We just build machines on machines on machines, programs on programs on programs. And we expect them to work a certain way, and generally they do. So to say that it can't be mistaken is silly. We all know that it can be, that it will produce a result that we didn't foresee, that it will produce a result that's erroneous. And so I don't want to assign intention to a machine. The machine's lying, but to say that it can't get something erroneous or make a mistake would just be silly. We have to acknowledge that technology fails frequently, and it's a product of human beings programming things. How can you know the outcome of something, months or years down the road? You set a program to do a certain thing, and then new variables are inputted, and the result comes out you didn't expect. It happens all the time.
Yeah, and I think it's a good distinction to make. I also, though, do take it one step further with the human element to say, there are times where we found that police have planted things on people or done things to make people look guilty. It's not to say that no one wouldn't ever do that. Now, I'm not saying that in general, they're programming cameras to capture everyone at 45 that's going 45. But when you have technology, well, it could be messed with. And what do you do then? And even could it be hacked? We have basically everything gets connected to the internet. They're not closed loop systems. And so even then, let's say that the police and everyone's great, but Russia hacks it or some teenage kid hacks it thinking it's funny. Again, it goes back to this thing of, oh shoot, how do we prove these things? And maybe we don't care. Maybe traffic violations aren't important enough to care about, and we let that happen. But I still look at it and say, from a check and balance perspective, when you add up the fact that software breaks and just fails, or it just produces a weird outcome sometimes, because sometimes the variables all line up in a way that wasn't anticipated. You can't recreate it, and it just does something wild. But that does happen, whether it's some sinister person that's got a vendetta for somebody or planting evidence or whatever, or a hacker. I don't think we have a great check and balance system in place for use with technology in these scenarios. And so we still have this situation where there's a lot of tension with police use of technology. And I think the way that most police use it is they use it as a tool, but they don't fully tell everyone. And it's not like they hide it, but they're not, publicizing it of how much technology is assisting them. And then they still go and do their last little bit themselves and then come testify and things. But we have drones. We have quite a few drones now. New York flying drones to find how many people are on a property, a number of things. But even then, the drone will spot people and then the police will show up, and then the policeman will say, oh yeah, there's 20 people here and there's only supposed to be 10. So it's interesting to see how they're rolling it out and using it, but it is one that from the AI perspective, we definitely need to have more discussions around of how to provide appropriate check and balance with these. And then compulsory process for obtaining witnesses in your favor. That means you can require someone to come into court and testify, even if they don't want to. And that's, again, a positive right. We're forcing someone to do something. But that is one that's determined to be pretty important. And then the last on the list is to have the assistance of counsel. And this is one that hits close to me as an attorney, because for a long time, attorneys would just be appointed to service somebody to fulfill this right. And it's one where I see a very strong positive right, is to say, well, man, I get to be crazy morally opposed to representing somebody, but just because I'm an attorney, I'd be forced to. And currently, courts and cities and states have set aside budgets to hire what they call public defenders. And and so people choose to be public defenders, and they're not currently forcing attorneys to take cases generally. But in theory, it's still a possibility that they can do that, and the courts have the power to do that, to require that attorneys take a case and defend somebody. You see that in books like To Kill a Mockingbird, where he's appointed and defends. And it's an interesting right, again, from the complexity perspective, from the cost perspective. It's fascinating to say, well, are you really defending yourself? Because public defenders are often overworked. They often can't put all the time necessary into it that a private attorney that you would hire would be able to put into it. And so you don't always get the same level or quality of representation as someone with more money that can hire an attorney. And so that's always one I've wondered about, is if you have a right to assistance of counsel and they appoint someone, but the person's so overworked that you don't even get to hardly talk to them, at what point was it not really effective assistance? And courts do look into that some to see if they do have tests for effective assistance of counsel. But I don't believe they're necessarily anywhere near the same level as what you could get if you had money and could hire a private attorney. So it's an interesting thing with the Sixth Amendment. But one another, on the flip side, the other thing is, can you waive that right? Can you represent yourself? And in general, the courts will let you waive that right and represent yourself. In general, they'll let you waive the right to cross-examine witnesses, to call witnesses. But there are times they won't let you waive the right to have an attorney represent you. If the court determines you're not smart enough or you're mentally too troubled or something, they can say, no, we're going to require you to have an attorney so that you can have a fair trial. Otherwise, you'll just get up here and look crazy, and that won't go well for you. So there are people that have tried to fire their attorneys and have been told no by the courts that they have to keep them. And again, usually a client wants to fire their attorney because they have a serious disagreement on how to proceed in a case or the strategy to use. And so, there are people that feel very, very that the laws are very unjust. The judges were unjust in making them keep an attorney that they didn't like. But it's always an interesting thing for a judge to go through to say, this person wants to fire their attorney. Can they do themselves justice in defending themselves? Or do I make him keep the attorney? And to your earlier point, Michael, about the complexity of the system, it's very difficult. And I guess one thing we probably forgot to do is when you talked about misdemeanors and felonies, a misdemeanor is generally a crime that you can be put in jail for of less than a year. And a lot of misdemeanors are around 3 to 6 months that you might go to jail max. a lot of misdemeanors, if you're found guilty of them, you end up doing public service and some probation time probably, maybe only a little tiny bit of jail time. And those, one interesting thing too with a misdemeanor is you can actually be sent to jail for up to 6 months per charge without a jury. The Supreme Court doesn't require a jury for misdemeanor charges of 6 months or less, even if there's multiple charges that could put you in jail for more than 6 months. And then felonies are generally jail time of a year or more, and they're a lot more serious on your record. And so some states have set up systems where felonies are a more complex process, misdemeanors aren't as complex, it's a little bit easier. And certainly if it's capital punishment involved, where you might be put to death, those cases require the highest level of work and proof and all kinds of stuff. There's so many attorneys that touch a capital case. It's pretty intense if they're going to allege the death penalty of all the resources that go into it. And so again, we've put a check on the government to say, hey, let's require a lot if they're going to try and put someone to death. But then in the same vein, a state or city can easily spend millions of dollars on a trial where they're trying to convict someone of death. And so it certainly has made it so that naturally the system is pursuing probably fewer and fewer death penalty charges against people. It's expensive, costs a lot, it gets a lot of bad press. But there still are situations that arise where a lot of Americans feel it justified, such as with the Boston bomber. That was in a state that was very traditionally opposed to that, but decided to pursue the death penalty with the egregious actions that took place. I would imagine if the recent shooter in Maine had been found alive, that most people would have wanted the death penalty to be pursued there as well. So, but again, it makes kind of for a natural check and balance with the extreme cost. Sometimes they won't pursue it just to avoid the headache and hassle and just try and put people in jail for life. But again, Sixth Amendment overall, I believe, has some very important checks and balances in it against the government. And one reason we will feel frustrated when we see results and stories is because we live in a land of quite a bit of freedom, where for a lot of it, we're protected from a lot of government overreach. And that's a wonderful thing. And so, Mike, I don't know if you have any final thoughts or anything to say at the Sixth Amendment.
Just agree with a lot of what you said, that it's, if we keep in mind that this is for those just charged with a crime. Many times we think of those charged with a crime as guilty. We kind of prejudge it that way. But always put yourself in the shoes of being somebody who is accused of something you didn't do, and what kind of protections you'd want. You want to allow people to accuse somebody of doing something. That's very important. And you want to also allow the person being accused the right to defend themselves, the right to be able to show their innocence. And so throughout that process, how would you want it to work? You got to kind of put yourself in those shoes and say, that's kind of what the Sixth Amendment is trying to support. If an individual is accused, whether they actually did it or not, we can't decide that until there's a trial. So throughout that process, let's make sure that we provide them with the proper rights. And then I think, to your other point, we think of these as the rights for the accused, but especially with regard to the speedy trial, the accuser, I think, has some rights there. If I bring an accusation forth and it gets batted around for a couple of years, it may be harder and harder and harder to convict somebody, where that speedy trial should apply to both the accused and the accuser, I think. And so just a couple of things to think about. Sixth Amendment there to try to maintain rights for those who are accused and the accusers, to make sure that innocent or guilty were given the proper treatment.
Yeah. And I think, again, this is an area where the Founding Fathers did pretty well. I think they struck a pretty good balance for the most part here. And it's one where could use a little bit of tweaking or correcting, but overall is doing pretty well. That isn't to say that all the things involved with the system or the lengths involved are appropriate. I do believe we could move things through faster still. But that's a discussion for more when we look in depth at the courts and what goes on and how they set things up there. So we will follow up more next week. We'll actually talk more about juries next week. It's the Seventh Amendment. And this will focus a little bit more on juries and the civil lawsuit side. And I think we'll go into looking some at some of the actual cases that come up. We talk about complexity. We talk about why are things so complex. And to look at a little bit of both sides of the arguments with juries in civil suits where we get into big antitrust lawsuits with Microsoft and Apple or patent disputes or other things. And so it should be pretty interesting to look at the heart a little bit more of what some people in America are called to sit on. And the fact that some trials do take 2 months and you can literally serve on a jury for 2 months. Because we'll see a little bit maybe of the side where the jury system, the complaints start to come in about the jury system and where the breakdowns start to happen. And so it'll be interesting to explore there. So thanks for being with us this week, and we will plan on following up more next week. Thanks so much.